So Bill Gross, the LA probate expert, and it's unbelievable how often we get properties where there's somebody in there who shouldn't be in there. And what do you do about that? Well, one of the steps is call a proper attorney. Well, a lot of attorneys do evictions. I've recently been working with one that's been successful, and Kendall Law, and Eileen Kendall in particular, specializes in this area and do a great job. And so I got a chance to talk to her today and want to share with you what we discussed. So, hey, Eileen, how are you doing?
I'm good. How are you?
Fantastic. So give us a little background. Where's your office located?
Yeah, we are in Torrance. We are on the corner of Crenshaw and Torrance Boulevard.
Very nice. And give us a little background on you. Where'd you grow up and how'd you get into the practice of law?
Yeah, so I was born in Buffalo, New York, but I call California home. We moved out here when I was in the 4th grade. I am a product of divorce, so I spent some time in Georgia back and forth between parents. Ended up going to school at Washington State University and then went to law school in Gonzaga.
Oh.
I don't know. I always wanted to be a lawyer from middle school. The idea of lawyer changed over time because as you grow older, you realize, oh, that really isn't how it works. But I remember at one time, I wanted to work at the top of Capitol Records. I wanted to be Capitol Records attorney because I wanted to be in downtown in the top of that building. I'm
Wow.
sure it's not where they work.
Yeah, I don't think they have attorneys up there. I would guess that'd be more for talent or for sales or something. But,
yeah, for something. But when you're in middle school, you don't have any idea. And so I just kind of molded everything I've ever done towards, practicing law. Been doing it now, oh gosh, nearly 20 years, I guess.
Wow. So, and then how'd you get into evictions and real estate law?
Yeah, so I went and opened my practice 6 years ago. I left corporate, a firm, and when you're trying to market, because my whole background is real estate litigation, and when you're trying to market that, it's hard to market. But I joined a BNI and evictions. Everybody understands those. Not everybody needs those, but lots of people need them. And I had worked for a foreclosure defense firm, and we would always get messy foreclosures because we worked for the banks where there was people still in place after the foreclosure. So I did evictions in that scope. And so I just started marketing it. And, it was a predominant part of my practice, but I would say more 60-40 with the general real estate litigation. Like we do easement disputes, boundary lines, things like that. Specifically, I speak and do a lot of risk management talks for real estate brokers on disclosures. So I do a lot of that. But when the pandemic hit, my panic was I was going to lose all my business. I tripled business with the pandemic. So now for evictions are probably 90% of our practice. I went from just one person at the pandemic to 7, I think 8. Wow. Maybe I just hired my 8th person. That's how much work is flowing in. I have one property management client that just sent us 30 files in October. So we are evicting people. Yes, I'm heartless. I'm that person. I'm contributing to the homeless situation.
Well, frankly, I appreciate you saying that in jest. I'm often on the other side. I think you are too, where I have a probate client and we're evicting somebody and people say, well, oh, you're heartless. You're trying to help evict somebody. But my client oftentimes is desperate for the funds. I had one where the decedent was a war hero. He had a house free and clear. The money was to go to his wife when he passed. Instead of her getting the money, and she was in a care facility that was horrific because she was basically on Medicare. And meanwhile, she had this $800,000 property free and clear being held up by the squatter. And so when somebody said to me, you're being heartless, I said, no, my client is suffering. And her husband worked for her to have good medical care and to have a good life. And this other squatter is just violating the law. So I know you agree with this, but I'm just, for the people listening, sometimes it's easy to say it's heartless to get squatters out because there's homelessness. And the flip side is usually there's somebody there who owns the property who's suffering along with that as well.
Absolutely. And that's why I represent landlords. Most of my landlords are mom and pops. This is generational wealth. And I feel terrible for them that they have some tenants that are taking full advantage when they shouldn't be. They're going on vacation and they have brand new cars, but they don't want to pay the rent.
So let's talk about it a little bit. I I'm sure that you have property management clients and some are really good and do everything proper and still end up with tenant problems. And you have other ones who make stupid mistakes and you say to them, what the heck were you thinking? Why didn't you call me ahead of time? So there's obviously no perfect solution, but what are some of the mistakes that property owners make that make it more difficult or make it more likely they're going to have problems down the road?
Well, one that I see is not having a good lease, not having a paper trail, not renewing a lease every year. When the kids become adults, because a lot of the things that I see are leases where they're 15, 20 years old. They don't have a lease anymore. There's like 5 people in there. They may have been minors at the time, but not going through the process of just keeping it updated, specifically to rent increases. I get so many people that come to me so upset that they're not at market, but they haven't. And a lot of times it's something that's inherited or they're taking over for their elderly parents, but not doing the annual rent increases, especially when we're dealing with caps in all of these different jurisdictions. You've got to do it every year. Otherwise, you just get stuck being too below market. And then I'm sorry, there's not much I can do when they call
Right.
and say, I want to raise the rent 20%. No, you can't do that.
Right.
But I think that those are some of the biggest issues that I see is not having the proper documentation, not having records just in general,
Right.
making sure maintenance requests are documented and there's correspondence showing and saving those things. We just did and finished a litigation that my poor client spent about $40,000 on to get him out. And he didn't have anything. Like the hardest part was everything was like piecemeal, but no good record. And this tenant was insane.
Do you see, or are you involved with from time to time cash for keys where you have these problem tenants?
Cash for keys is gold.
And so what kind of, I interviewed another attorney who operates in San Francisco, specializing in evictions and such. And he was saying that it's fairly common that tenants would get $40,000 to $50,000 or so for property. And I understand why it makes sense economically. As a real estate broker, you increase the value of the property by 100 to 150,000 if you can do it. Do you see those cases happening? Do you see sellers willing to, or tenant owners willing to pay those kind of fees, or are tenants able to hold off that kind of money?
Yeah, my guess in San Francisco is that their rent stabilization ordinance probably sets those dollars amount. I have personally never seen a cash for keys that high, even if you are in, and that's just me personally, I'm sure they're out there. But if you are in a rent stabilized property in LA City, the only amount that they're required to have, even at the highest amount, is somewhere in the $20,000. So I have had clients, I had a realtor refer somebody to me that wanted to buy a property, and we were trying to do a cash for keys, and they offered somewhere in the 30,000 range and moving in this and that, and it was still declined. So sure, I can imagine that you get them. And I bet you when you have some of those habitability type cases with the big apartment buildings in LA, those are probably closer to the 20, 30,000 range. But I've personally not seen any in the 50s.
Do you, as an attorney, negotiate those, or the client just brings you the deal kind of packaged together already?
It depends. A lot of times I think that it's always better for the parties to do it, because if you have an attorney involved, it becomes adversarial. Then they feel like they have to go get an attorney. So typically I console with them and they go and have that talk, and then they negotiate it. I prepare the agreement and then they present it.
And we say you prepare the agreement. So as a realtor, there's a California Association of Realtors form. Do you use your own? You have a custom form that you create that you feel?
Yeah, I don't know what's in the car form, but especially if you have something that's in an RSO, and even not even city of LA, but if you have Burbank or Glendale, they have very specific language that has to be in the cash for keys. And then they have to be provided to the board. And so my guess is the car form is very generic, and wouldn't have all of the different jurisdictions, because there's at least 10 cities that have special language that you have to have in your cash for keys.
Probably and growing every year. If you say there's 10, it might be 11th. Yeah, it might be 11th after today, right? Who knows what's. And then when you had the cash for keys, how, in your experience, how does the money get transferred? Meaning, if they don't move out, the whole deal is for naught. If they're in, if you're buying the property, ideally you want them out before you close escrow. How does that money get transferred? Do you hold it as a trust, and are you the intermediary? Is there an intermediary that you work with?
No, so it depends, because there are some cities that require you to put it into an escrow. Typically how I negotiate them is, a lot of times they're under market. And so it's going to be a very big sticker shock, and it's going to be very hard for them to find someplace. So I usually have it 50-50, 50% upon signing and 50% upon turning in the keys. Now, obviously, once you pay that 50%, you're probably not going to get it back unless you sue them. But I don't know if I've ever seen cash for keys where they haven't moved out.
Okay. Well, that's good to know. And so you see people who, I'm sure you see this, I see it all the time, where there's other, what I call attorney services. There's an attorney by name, but from where I sit, it's just more about, they'll file paperwork, and as soon as a problem, they just kind of walk away, and they'll kind of process 90% of the easier cases and take the 10%. Do you, at that point, do you step in, or how? Because obviously the customer, when I get to them, they're hesitant to change horses. There's an attorney already involved. Do you get those cases where they've started a eviction through either service or do it yourself or something, and then take over?
I got one yesterday, and an attorney that I used to work with refers a lot of matters to me, and they have a counsel that's just keeps continuing trial, doesn't have any pressure on it. And so we had a conference call, and they're firing them and hiring me. And what happens is, once they hire me, I reach out to the attorney. A lot of times these, for better words, these mills, they're all about high volume. And I do find that sometimes they'll hold the file hostage. You have to like pay a fee to get it. But I would sub in and then just take over the case. When there is a service involved, obviously they're doing it pro per, so there's no subbing in of attorney or changing that. Then I just step in, and then I have clients come to me after one of those eviction firms have messed it up or lost, and they come to me because they are about high volume. And so I think once it gets a little hairy, because my cases are, I mean, we have a lot of basic, but most of our ones that we get are on the more hairy side.
Well, that's why I reach out to you and your staff member, because the one I was involved with was very hairy. One of the hairiest litigations I've been involved with as a real estate agent successfully, and the attorney, who I really respect, one of the best attorneys I've ever worked with, recommended you for it. Now, he's obviously competent, he's licensed. You know, theoretically, there's no reason why he couldn't do it himself. He just would never do it himself because he does what he does, and he referred to you as the experts in the field. And that's why I jumped off the page to reach out. I appreciate your time.
No, you're welcome.
Is there a difference between a tenant who maybe is a deadbeat or doesn't want to move out, or you know, encouraged to move out legally, and say an heir on a probate case, maybe a relative who is one of 4 or 5 siblings? This is a classic case in probate where mom and dad had a house, one child stayed there, they're not paying rent. Maybe they're maintaining the properties to some degree. Maybe they're paying property taxes, insurance, maybe not. But are their legal rights different than a tenant? Are they more easily evictable or removable than a regular squatter of sort?
So those are ones that you get creative. It typically, you know, the trustee has to sell the asset to pay out the dividends or whatever it may be. We've had situations where the sole heir was the person living there, but he was high on meth and blowing up microwaves, and they needed to sell the home to pay for his special needs trust forever. And so we terminated it. I can't remember what basis we used, but we were like, here, you know, we'll agree to pay the security deposit and do this and get you set up. But, you know, it's not like we were totally putting him out on the street. But then you have situations where you have an heir, and what we do is if there's certainly no rent, like if you can show that there's no rent and they're staying there at the invitation of a parent, it's an at-will tenancy. And what we do is, I have a fiduciary that I work for, and we have that, and we do notice of death of the owner and termination of the at-will tenancy. Because the at-will tenancy, which is just basically one where you're a friend or a guest and you don't pay rent, there's no lease, there was no definite time that you were supposed to stay, that terminates 30 days after notice of the death. So we've created a notice that kind of puts the case law out there, and we've been successful on getting them out. I mean, 99% of the cases settle without a trial. And it's just working it out. But yeah, I mean, you just have to be creative in going through the facts of the scenario. You know, we have one that I'm just doing now, where we're doing it more as a squatter, is because there was a case in the probate where the court ordered the return of the asset, voided the deed, and he refuses to turn over the asset. So we did it on a squatter's notice.
Wow.
And of course, the other side is challenging that, but.
So when oftentimes I'll come to a client who has these situations, and I'll say, you need to get an attorney, and they'll say, well, what's that going to cost me? Can you, you know, I don't mean to bring it all down to money, but at some point, that's probably one of the biggest deterrents for customers to get the legal advice they need and evaluate their options. Are you able to share kind of like on the case of the at will? And I think the common case is the decedent had a girlfriend, or, you know, a woman who claims to have been a wife, or
Yep, I've
you know,
had lots of those.
or caregiver, right?
Yep.
And so the decedent's gone, and the son or daughter want to sell the property. What is a seller? Do they consult with you ahead of time and you evaluate the case and give them at that point?
Yeah, so
game plan,
it depends. So we have an intake specialist. Her name is Marilyn. Sometimes people just hire me, and they don't have to go through the consult, but it's a half-hour consultation for $240, and I can walk through the scenarios. The average cases are contested are anywhere from, you know, and when I mean contested is that they're fighting it. You know, there's some discovery, there's court, there's this and that. They range from, you know, 14,000 to the highest I've had was a nightmare of a case was 40,000. We are hourly, so we get a retainer at $7,500 for a retainer. Now, we get lucky, it's uncontested, or we get it settled really quickly, you're doing it for the 7,500 or less. But most of them are in that $14,000 range pretty quickly.
And so they would normally just call and talk to your intake person, and then they would kind of give, at that point, move them forward with you or not, or give them their options, or
yeah.
with you, and is that the consultation costs $240, you said?
Yes.
Okay.
So, you know, her job obviously is to try to sign cases without having consultation. So on eviction cases, if you want to move forward, you can just sign up and we can just get going. Right. But if you want to have questions or want to have a feel of what it's about, then we can do the $240 consultation.
Is there much of a difference in cost to the owner or the estate of a tenant who stops paying, doesn't want to pay, thinks they don't ever need to pay again, versus a squatter, somebody who comes in without any, it's the same process, really?
Yeah,
same court, same judge.
And it just depends. What I always say is it depends on what the other side does. I mean, if they go and represent themselves and they file for a court trial, you're probably looking at the $10,000 to $14,000 range. But if they get an attorney and they demand a jury trial, and then there's discovery and there's depositions, it easily exceeds that. But the process is the same, the timeline is the same. It all depends on what the defendant does.
Got it. In probate cases or trust cases, do you ever have clients who have to advance against their heirship in order to pay for the fees? Is that something you come across from time to time?
I've never asked. They just pay it, so I don't know how they're getting the funds.
Got it. Okay, good. That's a product we use a lot, and I know it's somewhat controversial, and we always want to use it like any powerful tool, you know, for the client's benefit. But it seems like more and more it's becoming available for clients who are property rich and cash poor. Well, look, I should appreciate. So if someone want to get a hold of your firm to see about what their options are, I know your website is kendalllaw.net. I'm going to put up here on the screen and share it. And then on the website as well, you have the phone number 310-619-4941. And so you can call in and talk to the intake person and or schedule a consult. And then from there, take it if you're serious. And I'll just say, that, I talk to a lot of attorneys and the staff say, oh yeah, we do this, we do that. And literally that happened to me with her firm. I had one matter in a probate and one of the staff members said, oh, we do evictions. And I thought, yeah, that's nice. Everybody says that. The best attorney I work with, the toughest eviction cases that I've ever seen go on. And I know it's gone on for years because I sold the house in that estate 2 years ago. We're now doing the commercial property, I think a year or 2 years later. And he told me that she's the best in the business. So Eileen, I really appreciate the time today to share with people and really encourage you if you have a tenant situation or a problem regarding real estate to give Eileen and her firm a call. Thanks so much for your time today.
Thank you so much for having me.